Ever wondered what actually happens, behind the scenes of your employment contract? What truly defines a fair day's work? Or how much leave you're genuinely entitled to?
Right. These aren't just company whims.
Exactly. They're not just arbitrary policies. They stem from a powerful legal framework designed for fairness.
And dignity in the workplace, really.
Today, we're doing a deep dive into a foundational piece of South African law, the Basic Conditions of Employment Act, Act 75 of 1997.
Often just called the BCEA.
Yes. Think of it as the bedrock beneath your working life, whether you're starting out managing a team or even studying labor law.
Our mission today is, to unpack this comprehensive act. We'll look at its core purpose, its key provisions, and, its real-world impact.
Breaking down the legal jargon.
Absolutely. Into accessible insights. So you'll walk away with a much clearer understanding of your rights and your responsibilities, too.
And to make sure we're getting this right for you, we're working directly from the Consolidated Act itself.
Yeah, the official text.
Incorporating all amendments right up to March 28, 2025, and noting its last review on April 11th, 2025.
So it's current. It's the living law.
This isn't just theory.
Not at all.
So let's unpack this. What's the fundamental why behind the Basic Conditions of Employment Act? Why was it actually created? What problem needed solving?
Well, the truly foundational thing here, I think, is that it's not just another law. It flows directly from South Africa's constitution.
Ah, the right to fair labor practices.
Precisely, Section 23(1). So it's ensuring fair labor practices are a fundamental right, which means these principles aren't just, good suggestions.
They're legally mandated minimal.
Exactly, upholding human dignity. Beyond that, the Act aims to advance economic development and social justice.
How does it do that practically?
By establishing and enforcing those basic non-negotiable conditions, things like the national minimum wage. It also regulates how conditions can be varied.
Variations. We'll have to get into that.
We will. And it ensures South Africa meets its obligations as a member of the International Labor Organization, the ILO.
Okay, that makes sense. Building a fair playing field. But who exactly is covered? Does it apply to absolutely everyone who works?
That's crucial. You need to know who's in and who's out. It applies broadly to all employees and employers. That's the starting point.
But there are exceptions?
Yes, a few niche ones. Members of the State Security Agency, for example, they have their own rules.
Right.
Also, unpaid volunteers working for a charitable purpose aren't covered.
Makes sense.
And there are specific rules for vocational training and for employees on vessels at sea. Well, the Act applies in a limited way there.
Limited how?
Mainly for things like severance pay, some definitions, and certain chapters on termination and rights, unless a specific sectoral determination applies to them.
Okay. And what's the legal standing of these conditions? You said they come from the Constitution.
Yes, and that gives them real teeth. The basic conditions defined by the Act are automatically considered terms of any employment contract.
Automatically, even if not written down.
Even if not written down, they're implied minimums. And here's the really important part. The Act takes precedence over any other agreement.
Any other. Like my individual contract.
Yes, whether it was signed before or after the Act started, unless that other agreement provides a term that is more favorable to you, the employee.
Ah, so it's a floor, not a ceiling.
Precisely. A solid baseline of protection. You can never legally be worse off than what the Act guarantees.
So if the Act's purpose is fairness and social justice, how does it translate that into, your daily working life? Let's get into the specifics, starting with working hours, always a big one.
Definitely. Chapter 2 covers this.
What are the limits? How long can you be asked to work?
Okay, so the Act sets clear boundaries. Generally, you can't be required to work more than 45 hours per week. That's the standard maximum for ordinary hours.
25 hours. And daily limit.
Yes. If you work 5 days a week or fewer, it's a maximum of 9 hours per day. If you work more than 5 days, say 6 days, it's 8 hours per day.
Okay, 9 hours for a 5-day week, 8 hours for longer weeks.
Correct. There is a small allowance, though, for people dealing with the public.
Oh.
Their ordinary hours can be extended by up to 15 minutes a day, but no more than 60 minutes total in a week, just to finish up with customers, that sort of thing.
I see.
And what's also quite insightful is the forward-looking aspect. Schedule 1 of the Act actually outlines procedures for a progressive reduction of hours.
A reduction. Towards what?
Towards a 40-hour work week and an 8-hour workday.
Really? So the Act anticipates shorter working weeks.
It does. It shows a vision for, continuous improvement in working conditions, aiming for better work-life balance eventually.
That's interesting. So those are standard hours.
Yeah.
But what happens when you need to work longer?
Yeah.
Overtime.
Yes. Section 10 deals with overtime. Crucially, it must be by agreement. Your employer can't just demand it unilaterally.
By agreement. And are there limits?
Yes. Generally, it's limited to a maximum of 10 hours of overtime per week.
10 hours max.
And importantly, your total daily hours, that's ordinary plus overtime, cannot exceed 12 hours.
Okay, so 12 hours is the absolute daily cap, usually. And the pay.
Remuneration must be at least 1.5 times your ordinary wage. That's the minimum overtime rate.
Time and a half.
Or, alternatively, agreements can allow for paid time off instead.
How's that work?
Either 30 minutes of paid time off at full pay for every hour of overtime worked, or a full 90 minutes of paid time off, but just at the ordinary rate for each hour of overtime.
Options there.
There are, and collective agreements, like through a union, can actually extend that weekly overtime limit to 15 hours.
15? Wow.
But only for a maximum of 2 months in any 12-month period, so it's limited.
Okay, so there's some built-in flexibility, especially with agreements. How else can working time vary?
Well, the Act allows for what are called compressed working weeks and averaging of hours.
Compressed weeks, like working longer days but fewer days.
Exactly. A written agreement can let an employee work up to 12 hours in a day without getting overtime pay.
12 hours straight time.
Yes, but only if they still don't exceed 45 ordinary hours a week or 10 hours overtime and work on no more than 5 days that week.
Right, so the weekly limits still apply. And averaging.
Averaging allows ordinary hours and overtime to be averaged over a period, usually up to 4 months, typically through a collective agreement.
So busy periods and quiet periods balance out.
Kind of, but the average still can't exceed 45 ordinary hours and 5 overtime hours per week over that period, useful for seasonal industries.
And breaks. What about rest periods during the day and week?
Essential. The Act is very clear. You're entitled to a meal interval of at least 1 continuous hour after 5 hours of continuous work.
An hour lunch break, basically.
Yes, though it can be reduced to 30 minutes by agreement or even waived if the shift is very short, less than 6 hours.
And between shifts.
You must get a daily rest period of at least 12 consecutive hours and a weekly rest period of at least 36 consecutive hours.
36 hours, so a day and a half off.
Yes, and unless agreed otherwise, that weekly rest must include Sunday.
Ah, Sunday. What about working on Sundays or public holidays? Pay implications there, I assume.
Definitely special rules. If you work on a Sunday and it's not a day you ordinarily work, the pay is double your wage.
Double time.
If you ordinarily work on Sundays, say in retail or hospitality, then it's 1.5 times your wage.
Okay. And public holidays.
Work must be by agreement. If you work on a public holiday you would normally work, you get at least double pay. Or, if it's more, your ordinary wage plus what you actually earned for working that day.
So, properly compensated for giving up the holiday.
That's the idea. It ensures those days are genuinely compensated.
What about night work? That seems like it would have specific rules.
It does. Section 17. Night work is defined as work between 6 p.m. and 6 a.m.
18 Bevan 0 to 06.00.
Right. An employer can only require it if there's an agreement if you're compensated.
Compensated how?
Either with an allowance, like shift allowance, or through reduced working hours. And crucially, transportation must be available between your home and work at the start and end of the shift.
Transportation is key for night shifts.
Absolutely. And for regular night workers, those working frequently between 11 p.m. and 6 a.m.,
How frequently?
more than an hour after 11 p.m. or before 6 a.m., at least 5 times a month or 50 times a year. For them, employers have extra duties.
Such as?
Informing them about health hazards, offering medical exams at the employer's cost if requested, and trying to transfer them to suitable day work if their health is affected and it's practicable.
So, real protections for the demands of night work.
Yes, it's a crucial layer.
Given how detailed these rules are curious, are there employees these working time rules just don't apply to?
That's an excellent question. And yes, there are exclusions, which highlights the Act's practical side. Chapter 2, the working time chapter, generally doesn't apply to senior managerial employees.
Senior managers, why?
The assumption is they have more control over their own hours and significant responsibilities. Also excluded are sales staff who travel and regulate their own hours.
Like traveling sales reps.
Exactly, and employees who work very little less than 24 hours a month for an employer.
Okay, very casual workers.
Right, and crucially, there's the earnings threshold.
Yes, you mentioned that. What is it currently?
As of April 1st, 2025, it's R261,748.45 per annum.
So if you earned above that amount,
then many of these detailed working time provisions, like limits on ordinary hours, overtime caps, averaging, night work rules, might not apply to you.
Why the threshold?
The thinking is that higher earners often have more bargaining power and control over their schedules, so they don't need the same level of granular protection.
Interesting distinction.
And for those earning below the threshold, there's another specific rule, Section 9A.
What's that?
If you work for less than 4 hours on any given day, you must still be paid for 4 hours' work.
Ah, a minimum payment for showing up, essentially.
Exactly. A safeguard against being called in for very short, perhaps uneconomical periods.
Okay, that covers hours. Let's move on to leaves.
Yeah.
Chapter 3, right. This is where many employees really feel the direct benefit.
Absolutely. This covers the essential time off. First up, annual leave. Section 20.
The holiday time, how much?
You're entitled to at least 21 consecutive days of annual leave on full pay for every 12-month cycle you work.
21 consecutive days, it's 3 weeks.
Correct. Or, by agreement, it can be calculated differently. 1 day off for every 17 days worked or paid, or 1 hour off for every 17 hours worked or paid.
Different ways to calculate, but the minimum is 21 days total.
Yes. And the employer has to grant this leave within 6 months after the end of the 12-month cycle.
Can't postpone it indefinitely.
No. And a nice touch if a public holiday falls during your annual leave period.
You lose the holiday.
No, you get an extra paid day off, so you don't lose out because you were already on leave.
Good to know. What about sick leave? That's vital.
Section 22 and 23. Sick leave works on a 36-month cycle.
3 years.
Yes, a 3-year cycle. During each cycle, you're entitled to paid sick leave equal to the number of days you'd normally work in a 6-week period.
So if I work 5 days a week, that's 30 days over 3 years.
Exactly. 30 days paid sick leave over a 36-month period. For new employees, in the first 6 months, it accrues differently. 1 day paid sick leave for every 26 days worked.
Okay. And the doctor's note. When is it needed?
The Act specifies that if you're absent for more than 2 consecutive days, or if it's the 3rd time you're absent in an 8-week period, your employer can require a medical certificate.
Fair enough. Now, parental leave seems to have changed a lot. The Act looks quite modern here.
It really has. This is a great example of the law adapting. It's much more inclusive now.
How so?
Well, you have maternity leave, of course, at least 4 consecutive months for the mother.
Standard maternity leave.
But then there's parental leave. This is newer. At least 10 consecutive days for any parent when a child is born, adopted, or placed via surrogacy.
10 days for any parent, including fathers or same-sex partners.
Absolutely, any parent.
That's significant.
Then there's adoption. Leave at least 10 consecutive weeks for an adoptive parent if the child is under 2.
10 weeks for adoption.
And commissioning parental leave also at least 10 consecutive weeks for a parent in a surrogate motherhood agreement.
Also 10 weeks. What if there are 2 adoptive parents or 2 commissioning parents?
Good question. They can choose. One parent takes the longer leave, the 10 weeks adoption or commissioning leave, and the other parent takes the 10 days of parental leave.
So they can decide how to share it.
Exactly. It offers flexibility. It's important to remember, though, that the payment for these leave types isn't automatic salary continuation from the employer. It's claimed as benefits under the Unemployment Insurance Act, the UIA.
Ah, so you apply to the UIF.
Correct. The employer facilitates, but the payment comes from the fund.
What about protecting pregnant employees while they are working?
Yes. Section 26. Employers cannot require or permit a pregnant employee or one nursing a child to perform work that's hazardous to her health or her child's health.
What if her job involves night work or potential hazards?
If it's practicable, the employer must offer suitable alternative employment on terms and conditions that are no less favorable than her ordinary job.
Okay, protection during pregnancy and family responsibility leave.
Section 27. This grants 3 days of paid leave per annual leave cycle.
3 days a year.
Yes, but only after you've been employed for 4 months and normally work at least 4 days a week.
And what qualifies?
It's for specific events. When your child is born or sick, or in the event of the death of your spouse or life partner, parent, adoptive parent, grandparent, child, adopted child, grandchild, or sibling.
Covers those urgent family moments.
Exactly. Those times, you absolutely need to be there.
Okay, so beyond hours and leave, Chapter 4 gets into the nitty-gritty of the employment contract itself and pay. What written details must employers provide?
This is about clarity from day one. Section 29 says employers must give employees written particulars of employment when they start.
Like a mini contract summary.
Essentially, it has to include key details. employer's name and address, employee's name, job description or brief duties, place of work, start date, ordinary hours and days of work, wage or rate and method of calculation, pay frequency, any other cash payments or payments in kind, and their value.
Wow, quite comprehensive.
Leave entitlement, notice, period, and if it's a fixed-term contract, the end date, plus any collective agreements that apply and where the employee can find them.
And what if the employee can't read it or understand it?
The employer has a duty to explain it to the employee in a way they understand, and they must keep a copy for 3 years after the employment ends.
Transparency is key.
And Section 30 reinforces that. Employers have to display a statement of employee rights under the Act at the workplace, and official language is used there.
So you should always be able to see your basic rights posted somewhere.
Ideally, yes.
And the actual payment. How, where, when.
Section 32 has precise rules. Pay must be in South African currency. Yes. Paid daily, weekly, fortnightly, or monthly. Either in cash, by check, or direct deposit into an account the employee nominates.
What if it's cash or check?
Then it has to be handed over at the workplace, or a place agreed to during working hours or soon after, and in a sealed envelope if requested.
Sealed envelope. And timing. When must you be paid?
Within 7 days after the completion of the pay period or within 7 days of termination.
Okay, can't delay payment excessively.
Okay.
And pay slips.
Mandatory. Section 33. Employers must provide written information, the pay slip, on each payday.
What has to be on it?
Employer's details, employee's details, pay period, wage rate, overtime rate, hours worked, ordinary and overtime, any other payments, details of any deductions, and the net amount paid. Full transparency on your earnings.
That brings us to Section 33A, Prohibited Conduct. This sounds important. What can employers do regarding payment?
This is a critical anti-exploitation measure. It makes it illegal for an employer to demand any payment from an employee or someone seeking work just for being employed or for getting work allocated.
So no fees to get or keep a job?
Absolutely not. Nor can they require you to buy goods or services from the employer or someone they nominate.
Unless.
There are very limited exceptions, like if the employee gets a clear financial benefit from it, or the price is fair and reasonable, like for accommodation or meals provided as part of the job under certain conditions. But it stops employers forcing you to buy things just to chip away at your wages.
Right. And deductions. Can employers just take money off your pay?
Only under strict rules. Section 34. Generally, deductions need your written agreement for a specific debt.
My agreement.
Yes. Or the deduction must be required by law, like UIF or PayMe, or by a court order or arbitration award.
What about deductions for damage or loss caused by the employee, like breaking equipment?
There are limits there, too. The loss must have occurred, the employee must be at fault, there must be a fair procedure allowing the employee to respond, and the total deduction can't exceed the actual loss and must not be more than 1/4 of the employee's pay in money.
So protections against unfair deductions.
Yes. And if deductions are made for benefit funds, pension, medical aid, etc., Section 34A says the employer must pay that money over to the fund within 7 days.
Ensuring your contributions actually get there promptly.
Exactly. Holds employers accountable.
Okay. And inevitably, employment relationships end. Chapter 5 covers termination. What about notice periods?
Section 37 sets minimum notice periods based on how long you've worked there.
How long?
If you've been employed for 6 months or less, it's 1 week's notice.
1 week.
Between 6 months and 1 year, it's 2 weeks' notice.
2 weeks.
And if you've been employed for 1 year or more, it's 4 weeks' notice.
Yeah.
Also, farm workers and domestic workers get 4 weeks' notice if they've been employed for more than 6 months.
4 weeks for longer service. Can the employer just pay instead?
Yes. Section 38 allows payment instead of notice. They can pay you the remuneration you would have earned during the notice period and ask you not to work it.
Okay. What about severance pay? When is that required?
Section 41 covers severance pay. This applies if you're dismissed for operational requirements.
What does that mean? Retrenchment?
Essentially, yes. Dismissals based on the economic, technological, structural, or similar needs of the employer, not for misconduct or poor performance.
And how much is it?
The minimum is 1 week's remuneration for each completed year of continuous service with that employer.
1 week per year. Is there any reason you wouldn't get it?
Yes. You're not entitled to severance pay if you unreasonably refuse an offer of alternative employment from that employer or another employer arranged by them.
So if they find you a comparable job and you just say no without good reason?
You might forfeit the severance pay.
And finally, when you leave, what documentation are you entitled to?
You have the right to a certificate of service under Section 42.
What does that include?
Your full name, the employer's name and address, dates you started and ended employment, your job title or a brief description of work, your remuneration at termination, and importantly, if you ask for it, the reason for termination.
Useful for finding the next job.
Definitely. Provides a verified record.
Now, Chapter 6 feels different. It tackles fundamental human rights issues, child labor and forced labor.
Absolutely. This chapter is a cornerstone. Section 43 prohibits child labor.
What's the age limit?
No work for children under 15 or under the minimum school-leaving age if that's higher.
15.
And it also bans any work that's inappropriate for a child's age or puts their well-being, education, health, or development, physical, mental, moral, spiritual, social, at risk.
So it's not just about age, but the type of work, too.
Exactly. And violating this is a serious criminal offense with significant penalties.
Are there any exceptions, like kids in TV ads?
Yes, there are very limited, highly regulated exceptions for performance work, advertising, sports, artistic, cultural activities. But even then, permits are needed, hours are restricted, supervision is required, earnings are protected. It's tightly controlled.
Okay. And forced labor.
Section 48, an absolute prohibition, consistent with the Constitution. No one may cause, demand, or impose forced labor.
Just a blanket ban.
Yes. And again, doing so is a serious offense with heavy penalties. These sections really underscore the Act's commitment to basic human dignity.
They're powerful protections, but a law is only effective if it's enforced. How does that happen? What if an employer just ignores these rules?
Crucial point. Chapter 10 deals with monitoring and enforcement. The front line is the labor inspectors.
From the Department of Labor.
Yes. Their job is to promote, monitor, and enforce compliance. They advise people, conduct inspections, investigate complaints.
Can they just walk into a workplace?
They have powers of entry, questioning, requiring documents. They try to secure compliance.
How?
Often the first step is to get a written undertaking, a promise from the employer to fix the problem.
And if the employer doesn't agree or comply?
Then the inspector can issue a compliance order.
What's that?
It's a formal document stating the provision that wasn't complied with, detailing the failure, specifying any amount owed to an employee, outlining the steps the employer must take, and the maximum fine if they fail to comply.
So it's a formal instruction.
Yes. Though there are limits, they generally aren't issued for disputes involving high earners above the threshold or for amounts owed for more than 3 years back.
You mentioned fines. Are they significant? Especially for minimum wage issues.
Particularly for national minimum wage noncompliance, yes. Section 76A lays out specific, quite severe penalties.
How severe?
For a first offense, the fine is the greater of twice the amount underpaid or twice the employee's total monthly wage.
Twice the underpayment or twice the monthly wage, whichever is more.
Correct. And for a second or further offense within 5 years, it jumps to thrice the underpayment or thrice the monthly wage.
Wow, that could be substantial.
It's meant to be a strong deterrent. Plus, the department publishes a list of non-compliant employers on its website.
Naming and shaming.
You could call it that. It adds reputational risk to the financial penalty, something many might not be aware of.
Definitely a strong incentive to comply. What if an inspector can't resolve it, or it's a different kind of dispute? What legal avenues do employees have?
Employees have clear paths. For disputes about non-payment, whether under the BCEA, the National Minimum Wage Act, the contract, or a collective agreement, employees earning below that earnings threshold can refer it to the CCMA.
The CCMA Commission for Conciliation, Mediation, and Arbitration.
That's the one. They'll first try conciliation. If that fails, it goes to arbitration, which results in a binding award.
What about other disputes, like being fired for asking about your rights?
Disputes about the protection of employee rights under the Act, like being discriminated against for exercising a right, also go to the CCMA for conciliation and then arbitration.
So the CCMA handles a lot of these day-to-day issues for lower earners. What about the labor court?
The labor court has exclusive jurisdiction over most other matters arising from the Act. It also shares jurisdiction with civil courts for general employment contract disputes.
And some things only the labor court can handle.
Yes. It has exclusive power to grant civil relief for the most serious violations. Things like the prohibited conduct by employers we discussed, child labor, forced labor, breaches of confidentiality under the Act, or obstructing officials.
And proving your case, is it always on the employee?
Actually, no. And this is important. In many cases, the Act shifts the burden of proof to the employer.
How so?
For example, If an employer fails to keep the required records, they have to prove they complied with the act. If they can't prove it, they're presumed not to have complied.
Makes sense if they didn't keep records.
Similarly, if an employee claims their rights were infringed, say, they were disciplined for refusing an unlawful instruction, the employee proves the conduct happened, and then the employer must prove that the conduct did not infringe the employee's rights.
That levels the playing field considerably.
It does. It recognizes the inherent power imbalance. And the Act explicitly lists employee rights, like the right to complain, discuss conditions, refuse unlawful orders, inspect records related to their employment, participate in proceedings, and strongly protects against any discrimination for exercising these rights.
It's clear this act isn't just a static document frozen in 1997. It seems very much alive.
It absolutely is. You can see that from the numerous amendments over the years, adapting to changes in the world of work.
How does it balance setting minimums with allowing for specific industry needs?
Good question. It uses a few mechanisms. Chapter 7 allows for variation through collective agreements, especially those concluded in bargaining councils. These agreements can alter, replace, or exclude some basic conditions.
So unions and employer groups can negotiate different terms.
Yes, but, and this is critical, they cannot reduce certain fundamental protections.
Such as?
Things like the core entitlement to annual leave, maternity leave protections, sick leave provisions below the minimum, or the prohibitions against child labor and forced labor. Those are non-negotiable floors.
So flexibility, but not at the expense of core rights.
Exactly. The Minister of Labor can also make determinations of varying conditions, but again, with limitations.
And sectoral determinations, you mentioned those earlier.
Yes, Chapter 8. This allows the minister to set specific basic conditions for particular economic sectors and geographical areas.
Like for domestic workers or farm workers.
Precisely. Those are classic examples. Or contract cleaning, private security, wholesale, and retail. These determinations tailor conditions to the realities of those specific industries.
And if a sectoral determination exists,
then its provisions generally prevail over the main act for the matters it specifically regulates. It provides more targeted protection.
One other modern issue, the line between employee and independent contractor. Does the Act help clarify that?
It does, through a very important section, Section 83A, the presumption as to who is an employee.
A presumption?
Yes. If a person earns below the earnings threshold and one or more specific factors are present in their working relationship, they are presumed to be an employee until the contrary is proven.
What sort of factors trigger this presumption?
Things like the manner or hours of work are subject to control or direction by the other person. The person forms part of the organization. They've worked an average of at least 40 hours per month over the last 3 months. They are economically dependent on the person they work for. They're provided with tools of trade, or they only work for or render services to one person.
So if any of those apply, the burden shifts to the employer to prove they aren't an employee.
Correct. It's vital for tackling disguised employment or ambiguous relationships in, say, the gig economy, though this presumption doesn't apply to those earning above the threshold.
And the CCMA can help clarify.
Yes. For those below the threshold, the CCMA can issue an advisory award stating whether someone is likely an employee, which can help resolve disputes early.
So bringing it all together, what does this mean for you, the listener, whether you're an employee or an employer?
For employees, the BCEA is fundamentally your legal safety net.
Your rights defined.
Exactly. It defines your rights to fair pay, reasonable hours, essential leave. Knowing these provisions empowers you to check your contract, check your payslip, and advocate for fair treatment.
And for law students.
Oh, it's a fantastic piece of legislation to study. It's dynamic. It shows the interplay between the Constitution, international standards, and day-to-day workplace realities, constantly evolving.
And for employers.
For employers, it's your essential guide, your map to legal compliance, fair practices, and honestly building a more productive and stable workforce.
Avoiding disputes.
Understanding it definitely helps avoid costly legal disputes and fosters a better work environment. Ultimately, complying with the Act contributes to social justice and economic development, which benefits everyone in the long run.
So today, we've journeyed through the Basic Conditions of Employment Act, 1997. From its constitutional roots, who it covers, the specifics of hours, leave, pay.
Termination, the prohibitions on child and forced labor.
And importantly, how it's enforced and how it adapts. It really is the backbone of labor law in South Africa.
It is. And maybe a final thought to leave with everyone. As the world of work keeps changing so rapidly, think Gig economy, remote work, AI impacting jobs.
Big changes happening.
Huge changes. How might these fundamental principles in the BCEA, fair hours, leave, protection, need to be reinterpreted or even expanded in the future? How do we ensure fair labor practices remain a cornerstone for everyone, whatever new forms work takes?
That's a really interesting question. A lot to think about, isn't it? We hope this deep dive has given you a clearer picture, maybe sparked some curiosity to learn even more about your rights and responsibilities in the workplace.